Well, it's my pleasure to welcome and introduce Donna Vanderpool, who has both a business and law degree and is Director of Risk Management at Professional Risk Management Services, a professional liability insurance program for psychiatrists. She has particular expertise in the areas of telepsychiatry, HIPAA, forensics, and treating patients with suicidal behaviors. She has consulted, written, and spoken nationally on these and other healthcare law and risk management topics and contributed chapters to several psychiatric textbooks. I asked Donna to talk about an extremely important topic for all of us working with suicidal patients, and she will be talking about mitigating liability for clinicians working in all settings, including telepsych and using EMR. Donna?
As I'm getting set up, I really appreciate the opportunity to share my thoughts today. PRMS insures a lot of psychiatrists and has done so since 1986. We have a lot of information and data about patient deaths by suicide and attempts that are reported to our office. Not all of these reported suicides actually result in an action being filed against our insured psychiatrist. In fact, only 9.5% of reported suicides become a claim, which is a written demand for written demand for money outside of litigation or lawsuits. So today, in my time, I want to try to address two goals. I want to provide a brief overview of what we see in terms of our insured's liability for patient deaths by suicide, and then spend a little bit more time on providing some risk management advice to increase patient safety, which will decrease the clinician's liability. Please note, while I am an attorney, I'm not your attorney, so the risk management advice I discussed today is not legal advice. Okay, so here you can see the cause of loss or the primary allegation against the clinician for all of the claims, lawsuits, and administrative actions, which are simply investigations by a regulatory body, such as a licensing board, against our psychiatrist since 1986. Attempted suicide tops the list as the primary cause of loss in 28% of all of our professional liability cases. Now, in this chart, I removed the administrative action data, so it's showing just claims and lawsuits, and just for the last 10 years. The most frequent allegation with adult patients is incorrect treatment. Now, plaintiffs like to keep their options open until they get into the actual facts of the case, so they will plead the case initially as incorrect treatment, but that certainly can include a suicide. In terms of minor patients in this data set, suicide is the most frequent identifiable cause of loss. Now, if we look at just lawsuits for adult patients involving a suicide, for the last 10 years, this chart shows various breakdowns. Now, of course, we have had patients older than 67 die by suicide, just not in this time frame. So still looking at our suicide lawsuits with adult patients for the last 10 years, almost half of the patients had the diagnosis of major depressive disorder, and hanging was the most frequent method. Firearm, which you might expect to be the most frequent in our data set, was actually the second most frequent method, again, in this data set. Same data set, 82% were outpatient deaths, 18 were inpatient, 18%. A couple of comments about the death by inpatient suicide. 67% of those cases involved patient hanging. Other causes included jumping and cutting. And it's not unusual for those working in the hospital to be pulled into cases where they actually had no role, no negligence, such as a hospital door that should have been locked, but instead it was open, which allowed a patient to get out, climb to the roof, and jump off the roof. We know that status post-hospitalization for suicidality is an incredibly high risk time, and in cases in this data set identified as having deaths by suicide that were after discharge, 87% were within 1 month of discharge. Of these, 70% were within 1 week of discharge. And of these, 13% were the same day as discharge. So discharge planning is very important to keeping patients safe. In terms of resolutions of these lawsuits, 3% were just not pursued by the plaintiff, and 40% were dismissed by motion. So that's where the defendant clinician files a motion with the court and asks to be dismissed. 40% of these, the court agreed and dismissed the clinician. So 43% of these lawsuits went away. 56% were settled, 53% were settled prior to trial, and the remaining 3% settled during trial. All settlement amounts for this data set were below the insurance policy limits. And the remaining 1% of lawsuits in this data set, there was a judgment for the defendant clinician. If we look at our cases involving minor patients now, in terms of the ones with death by suicide or suicide attempt, I had to expand the data set here. This is going to be over the last 20 years just to get more data. You can see the age breakdown, and the majority were outpatient. And you can also see the most frequent diagnoses. Same data set, hanging was by far the most common method in these cases with minor patients. In terms of case resolution, 40% went away, 37% were by a motion to get out of the case. 50% settled before trial. 7% had a defense verdict, and 3% had a verdict for the plaintiff. So minor patients are a very vulnerable population, and jurors feel sympathy for the patient and for the family. You are not expected to predict suicide, but you are expected to perform an adequate suicide risk assessment, and then based on that assessment, assess if the suicide is foreseeable. You are expected to implement appropriate safety measures based on that assessment. For example, when discharging an inpatient from hospitalization due to suicidal ideation, one cannot predict that a suicide will or will not occur after discharge. There is no crystal ball. However, you can foresee that the failure to assess the patient for suicidality before discharge could lead to a substantial risk of injury. Now, fortunately, the courts understand suicides cannot be predicted. There just is no crystal ball. So what do the courts expect? What is the standard of care in a suicide case? And it really boils down to identifying risk and treating it appropriately. But we culled through all of our suicide cases and really narrowed it down to these 5 standard of care factors when treating patients with suicidal behaviors. You've got the adequate identification and evaluation of suicide risk indicators and protective factors, a reasonable treatment plan based on that assessment. The treatment plan was appropriately implemented and modified based on ongoing assessment of the patient's clinical status, being professionally current regarding the assessment and treatment of patients with suicidal behaviors, and documentation adequate to support that appropriate care was provided in terms of the assessment, treatment, and ongoing monitoring of the patient. So what is the risk management advice? So this is our current framework of risk management strategies. Now, you're looking at this going, I already know this, and that's the exact point. You already know these components to deliver good clinical care. We call them the 3 C's. It's collecting information, communicating, and carefully documenting. So let's delve into the first strategy, collecting information about the patient and about the clinical condition. First, collecting information about the patient, you need to assess, obviously more than once. You're going to assess at significant points in treatment. Consider the possibility of comorbid conditions such as substance abuse. Inquire about access to firearms. Get collateral information from patient's family perhaps if you're dealing with minors from teachers, etc. You should also explore past treatment. Obtain past treatment records for new patients for whom there could be safety concerns, if possible. If it's not possible, document your attempts. In one of our cases, the prior records, if they had been obtained, they would have shown multiple prior suicide attempts, which the current treater was just not aware of. Unfortunately, the records were not requested. And a great source of safety information about your patient that you may not otherwise get is to check the state prescription monitoring program just to confirm what meds the patient really has been prescribed. It's worth checking. Another part of collecting information is staying professionally current. Know the criteria and the process for involuntary hospitalization. Know the specific policies and procedures at the hospital where you practice. We've had, I would say, too many cases where the defendant psychiatrist just didn't know the specific policies and definitions at a hospital that they were new to. Just as an example, the psychiatrist didn't realize that a one-to-one order would automatically expire after 24 hours if it was not renewed. He didn't know to renew it, and that had an awful outcome. Be familiar with authoritative guidelines. And the biggest advice under collecting information is doing the suicide risk assessment and consistently utilizing a reputable suicide assessment and treatment methodology can reduce patient harm, which reduces the clinician's liability risk. So safety is the resource that I recommend. So I'm very excited with the news that the protocol is going to be integrated into the EHR. I think this is a great step in the right direction. It is available through SAMHSA. You can also download the Suicide Safe mobile app, which has additional resources and training to help providers integrate suicide prevention strategies into their practice. I cannot stress enough that the risk assessment has to be done, but also documented, okay? Just a few examples from our cases. One case, the hospital psychiatrist testified she didn't think she needed to do assessments of risk on any of her inpatients because she was on a unit where all patients were considered at risk of suicide. And then in this example, you really need to read the treatment record, particularly inpatient. So in this case, the social worker's notes documented current acute suicidality on the day the psychiatrist discharged the patient. And if I know about it, there was a bad ending. The discharge may certainly have been appropriate, but there was no documentation on the psychiatrist's decision-making process and addressing the contrary information in the chart. The psychiatrist, after being sued after the patient's death, testified that he never looked at other providers' notes in the hospital chart. Okay, just a few points about treating patients via telemedicine. There's definitely additional information to collect. If the patient's in a different state, the clinician needs to determine and meet licensure requirements in the patient's state. States vary. They're all over the board on licensure requirements. They're also starting to require, more and more states are requiring in-person visits with telemedicine, and it's not always related to prescribing controlled substances. States do agree on one thing related to telemedicine, and that is that the standard of care is the exact same for treating patients remotely as it is for seeing patients in your office. So if the patient goes into crisis during in your office, you are responsible for getting that patient hospitalized. The same is true when seeing patients remotely. If the patient goes into crisis during a remote appointment, the clinician still has the responsibility to get that patient to the hospital, to emergency services. To be able to do that, you need to get at the beginning of every remote session with a patient that's not in a facility or a clinic, the patient's exact street address. Now, I've been giving this advice for years prior to the pandemic, and I quite often get told by my psychiatrist, oh, Donna, based on my patients, that really is not necessary. And then I share with them, at least two of their colleagues that I know of, had that exact same thought until their patient attempted suicide on camera during a telemedicine visit. And I will say that as an example, Alabama is one state that has made this a requirement. It's right there on the board's website. The patient has to give their location. Second strategy is communication. And, we just talked about telemedicine. You've got to ensure that your communication method is appropriate for the patient. Telemedicine is not appropriate for all patients, but those utilizing it really should utilize audio visual. I think that you would want to steer away from using just email to treat patients with any type of safety issues. We did have a case where the patient who was being treated for suicidal behaviors was treated only by email, and that did not go well. The last email message was, thank you, you've been helpful, but now, the end has come. And there's no defending that case. There's just no defending that case. So make sure your communication method is appropriate. Let's see. And also, while I brought up email, we do know that, practitioners are starting to charge for email communications, whether it's an actual email or like a message through the portal. I certainly understand the need to ensure, manage patient contacts outside of appointments and make sure that doesn't get unduly burdensome. But I also have concerns that patients, if they have to pay for that, they may not pay when in fact they did need to talk to you or let you know of, say, an adverse event or a symptom that could be related to their medication. More on communicating with patients. Let's see. If you are prescribing medications and there is a black box warning, that needs to be covered in your informed consent discussions. Just a quick risk management tip. Maybe you want to consider utilizing the FDA's patient medication guides. You get them right online. They are meant for patients, so it's easy to understand. And 8th grade reading level, I believe. And what the FDA thinks patients should know about the medication is covered. And the most important is in the top left, which would include any black box warnings on the medication. All right. You may need to communicate with other healthcare professionals, other providers, whether it's for a consult, letting your covering know about your risky patients. You may need to be communicating with family members. Remember, patient safety or safety of others is an exception to confidentiality. You may have someone, a third party calling, wanting to tell you something about your patient. It is not a breach of confidentiality to say, I cannot confirm the person is my patient, but I can listen to what you have to say. And then my final communication point, you can see here on the slide. You may want to, even if the patient prohibits you, there are times when you may want to consider contacting the patient's family or significant others if you are concerned about the risk of an outpatient suicide. And these 3 factors, even if the patient says no, you may want to consider doing it anyway if the risk is significant. The family members do not seem to be aware of the risk, and they may be able to contribute to the patient's safety. Okay, getting to our final risk management strategy, and that is carefully documenting, as promised by Dr. Jacobs at the very beginning of this course. Adequate documentation is your best defense in any malpractice lawsuit. Remember, there's no such thing as perfect record. An adequate record will suffice. So why do we care so much about the adequate record? Easy. Plaintiffs' attorneys don't like care that is documented. They would rather make up their own version of what happened in your treatment years later. Okay, but your record is your defense. It allows your treatment to be understood by subsequent treaters, which, again, the purpose of the record is for continuity of care, by expert witnesses, and by you, if needed, many, many, many years after treatment if there's litigation. There's also a rule of evidence. It's the professional judgment rule, under which courts will give great deference to the treating physician as long as there's something to base that deference on, and that is your contemporaneous documentation. So what should be documented? You want to document what you did in treatment and why, what you considered but rejected and why. One quick point, if you are living in a state where you are not actually able to commit your own patient, you have to refer to some type of state mental health professional. Please, based on the cases we've seen, even if you know that state professional will not commit your patient, please make the referral. Again, even if you know it's futile. We've seen the cases where it was difficult to refute the allegation that the clinician didn't even care to try to get the patient committed. So I'm including on this slide, this is from, the APA's guidelines. I know they're labeled legacy. The information is still appropriate. Here's what you want to document. And here is when you want to document a suicide risk assessment. And I want to mention just a few of the risks associated with electronic health record documentation. Be very careful with automated documentation. Copy and paste. It should not be used unless you credit the original author. It is leading to massively bloated records with too much information, so important information can't be found. We had to settle a case recently because the entire record was the exact same note with just a date change. That's the only thing that changed. And, all they did was cut and paste. They didn't document. Templates, be very careful, make sure that they fit your patient. Pre-populated fields, default data. I'm sure there's lots of other shortcuts out there. I think that we need to distinguish between data entered by the physician or the clinician and the system-generated data. And your documentation has to be specific to your patient. Hopefully, if you're using an EHR, there is space, free-form text. That's perfect. Make something about that patient and that visit. And keep in mind, EHRs were never intended to be printed. So if you are using an EHR, you probably want to do a test print to see what might get cut off. So what your record printed says, that's very different from what it is in the EHR. And then my last slide, I want to conclude with some thoughts to keep in mind. If you do have a patient attempt or die by suicide, first thing, call your insurance company. They may have a different checklist than I'm presenting here. Don't discuss the case with anyone, not even another provider involved in the patient's care, until you have checked in with your insurance company. Do not change the record. If you're convinced something has to be changed, wait, and your attorney or your risk manager that's assigned to you to help you with this case will help you make any changes that are needed. Think about billing for your services. Ensure the record is protected. If it's paper, lock it down. It needs to be in a fire and waterproof cabinet. If it's electronic, lock it down as well so no one can access it. Be sure to keep all your correspondence with your attorney and your insurance company out of the patient record and get guidance before releasing the record for any purpose, whether it's a peer review committee or an attorney requesting records or the medical examiner even. Patient confidentiality survives a patient's death. You want to be prepared to deal with your emotions. Just keep in mind, not all adverse events are due to medical errors, and not all medical errors result in an action against the clinician. And lastly, be prepared to deal with the patient's family. You want any interaction to be driven by the family, but without breaching confidentiality. If contacted by the family, you may be able to offer support and express care and concern. All right, we have reached the end of my prepared comments. I hope that you have found them somewhat useful.
Donna, they were very useful indeed, and we thank you for your time. We have a number of questions that have come in, some really good ones. Let me see if I can run through a couple of these with you. First, a request to repeat the name of the medication database and explain how a clinician goes about accessing this information.
Sure, you can just search FDA patient medication guides, and then it comes up with a massive list, and you just click on the specific medication.
Great. What happens if a client refuses to sign a release of information for previous providers? Should that be documented?
It should be documented and depending on how much you feel that past treatment information is necessary. I hate to drag up HIPAA, but you can keep in mind that HIPAA makes two distinctions. There's consent, which is sharing information for treatment purposes, and then authorizations for everything else. You cannot condition an authorization on the patient. You cannot condition treatment on the patient providing an authorization to get records. There's nothing that says you can't condition your treatment on the patient providing a consent for you to obtain past treatment records. So if you feel very strongly that you need those past records and the patient says no, that's probably not a treatment relationship that you're going to be able to continue in.
You were asked if all patients are at risk on the unit, do we still need to evaluate for SI?
You're going to have something in the record because the patients are individuals, right? So you've got to have something that shows you thought about this patient on this date and what those thoughts were. They're not going to be the same across all patients.
Can you recommend risk mitigation practices for those in private practice?
Well, I think that's why SafeT is the resource that we promote, because I think it's very user friendly, and that's a great resource. Keeping track of your patients, if they don't make their appointment, remember you are technically on the hook for that patient until you formally terminate with that patient. Things like that.
It's an interesting question. Should we reach out to the family to offer our condolences, or is this potentially problematic?
So first, I'll defer to your own liability carrier's advice, but my advice to my insureds is it's going to depend on your relationship with the family during treatment. If you've never, ever had any interaction with the family, we don't advise interacting now. If they are with the patient at every visit, then that's maybe totally appropriate.
How does risk management come into play when patients need a higher level of care for their suicidal ideation, but beds are not available or insurance will not cover a higher level of care?
Yeah, I mean, that's tough. That's not really an answer that I have. I will stress that when dealing with insurance companies, you want to push and you want to spend that time to advocate on behalf of your patient's needs. And, when you get denied, you want to talk to someone else. You want to talk to another psychiatrist. You need to push as much as you can, because that may be what you rely on. But, you really have no control over certain things.
Let me work in a couple more questions before our time runs out. My agency offers one-off suicide risk assessments for local school districts. When assessed at a moderate level of risk and referred to services, what obligation to follow up with the youth's family might we need to consider?
Well, I think you would want to manage expectations from the very beginning. So when the family consents to you doing that type of evaluation, it's very clear that it's a one and done. There is no treatment. It's simply an evaluation. And then you've got that to rely on so that everyone's expectations are clear.
In an emergency room conducting an assessment, gathering records is not an option as we assess and determine a plan within a short period of time. Is this an issue for emergency services in terms of legal issues?
No, and I'm glad that you brought that up, because I should have made that a bit more clear. That is not what's going to happen in the emergency room. It's more so when the patient's admitted and the inpatient psychiatrist, on the unit is looking at this new patient, new to him. That's the psychiatrist to request those past treatment records if they can.
Okay, one more question. How do you adequately confirm securing of firearms?
So I'm not the expert in the firearms, but there are fairly standard, record firearm security resources. And I'll just mention Massachusetts Medical Society. If you search Massachusetts Medical Society and firearms, they've done some work on this. And, they may lead you to some of the advice for practitioners to talk about the firearms issue and locking up the firearms.
Donna, great job running through a whole bunch of questions there at the end. I appreciate that very much. That makes my job easy. We appreciate your time today, Donna.